This is the Divorganized session on the divorce process. My name is Amanda Dubois and I'm a practicing family law attorney, and as you probably know if you've been watching this series, I've put together a series of videos to teach basic legal principles about the divorce process. And we start each session by my reminding you that I can't give you legal advice and that this is not intended to be any kind of legal advice. This is intended to be an educational session to help you realize what issues you need to pay attention to as you're heading into the divorce process. So the way I'm approaching this is it's called issue spotting, and what issue spotting means, that's what they teach lawyers to do actually in law school, and that's how we study for the bar exam. We don't necessarily know exactly how it's going to be played out in any particular state, but we know what the issues are. So because your state might be different than my state, might be different from Kentucky or Illinois or California, all the states are very different in exactly how they implement divorce laws on the specifics. But the principles are basically the same, the legal principles, and that's what we're talking here. And issue spotting is one way to approach this. So we're going to talk about different issues that you have to be alert to in your particular jurisdiction. And today we're talking about the divorce process. And this is just an overview. So let's just talk about the divorce process you're entering into it. We've already done a session on how to prepare to file for divorce. So I'm not going to go into that at length. And we've done a session on what do you do if you're served with papers where your husband has filed for divorce against you. The first thing that has to be determined in most states is called venue. And venue is what county or what jurisdiction you have to file your papers in. Because in most places, and like I said, because states are all very different, it's going to be your responsibility to either consult with a lawyer in your state or in your jurisdiction, or to do some research by going to your state website or going to a website in your county that's set up for people that are representing themselves. And those people are called pro se, which is P-R-O-S-E, and it's pronounced pro se. And if you're going to go through your divorce without hiring a lawyer, which you may or may not want to do, and we actually have a session on lawyer yes or no, but if you're going to do it without a lawyer, then you're going to be held to the standard of understanding what forms have to be filed and how they have to be filed. And most counties or most states have websites set up for people, or at least they have an educational packet maybe at the courthouse that you can go down and pick up that tell you the steps that you have to take. And some courthouses and counties even actually have like a seminar that you can take, or some places in our jurisdiction now you're actually required, if you're pro se, you're required to go and sit through a class, so at least you know how to file your paperwork with the court, and you know what forms your pleadings have to be. And pleadings are those papers that look legal with the numbers down the side and the caption on the top. So all those things there's court requirements. In most places you have to do it exactly like they want it, or they'll throw your stuff out. So like I said, you might be pro se, you might work with a lawyer as a consultant, just go in and get the advice you need and then go work on your own and then come back to the lawyer and get some more advice and have them review your paperwork. Or you might want to hire a lawyer to represent you for the full divorce. So there's different ways that you can use lawyers and different ways that you can use resources, and it depends on your budget, and it depends on how contested your situation is, and it depends on the complexity of your case. But just be advised that there is a proper county for you to file your divorce in, and there are going to be requirements in your state that are going to be probably set out in your statutes or on a website through your courthouse, not on some website that you just go on and it's, you can't rely on a website just put together by a lawyer or some online legal service, which those could be fine, but if you really want to get the information, you should go to your state, the state or the county websites. So first of all, you got to figure out where you have to file and which county you have to file in, and it usually has things to do with where you live and where your children live and how long you've been there. In fact, some states have requirements that you can't file in a certain state unless you've lived there for a certain period of time. So you have to take a look at the residency requirements of the state, and then you have to figure out what venue or what county to file in inside of your state. So once you've figured out that you can file in a certain state where you live, and if there's a question about that, you really have to talk to a lawyer, because people that are in the military or people who have recently moved might have some challenges about which state to file in. So figure out whether you have residency requirements, figure out what state is appropriate, figure out what venue, which is the county, and then you have to file what's called either, in some states it's called a complaint for divorce, and in some states it's called a petition for divorce. And those are the two phrases that I'm familiar with, but that really covers most states. If you're in a state where you have to file a petition for divorce, then typically the person who files it is called the petitioner. So if you're the one who's filing, you'll be the petitioner, and the person who's responding to the petition is usually called the respondent. And if you're in a state that calls your initial filing is filed by complaint, then typically the person who files the complaint is called the plaintiff, and the person who responds to the complaint or defends against the complaint is called the defendant. So whether you're filing a complaint or a petition, you need to understand what are the requirements in your state for filing a petition or a complaint. And like I said, the best thing to do is talk to a lawyer, and we're talking here just about the process. So the initial, that's called a pleading. Anytime you file something in the court, it's called a pleading. So the initial pleading is filed, and let's just call it a petition for purposes of our discussion. The petition is filed, and then that gives the court, and then the court can take jurisdiction over your case as soon as the response has been filed. So petition, response. You've got your petition, which has to be served on the respondent, in the proper manner according to your jurisdiction. In some places, you can mail it with the certificate of mailing. In other places, it's necessary for you to actually serve it with a process server or a third party. So file the petition, serve it on the respondent, let the court know that you've served it. So there's usually some sort of a pleading that's like a confirmation of service or a conformatory pleading that says we've served it. Then the respondent, who's the person who's received the complaint, has to respond. In most states or jurisdictions, there's a time frame within which you have to respond. So going back to the petition, depending on your state, there's going to be certain required information that has to be included in your petition. And some of those things have strong legal implications. Be sure that you get some legal advice about that to make sure that that's properly filled out and filed with the court. Served, then you get a response, and now the court has jurisdiction over your world, and that sounds kind of scary, and it is. But it can be a good thing at the same time. So what that means is, once you've submitted yourself into the jurisdiction of the court by filing your complaint or petition, then the court can step in and make decisions for your family and your world. The court has the authority then to say who's going to pay what bills and where are the children going to live and who's going to stay in the house and all of the particulars that have to happen for your family during the time from when you file to when you get your final divorce, and then the court has the authority obviously to make a final ruling in your divorce. So the court now has jurisdiction. So you're going to come into some sort of temporary situation, which is, in most places it's called temporary orders, and in some places it's called pendanti liti, which I hope I said right, because we don't use that word in our jurisdiction. But what that means is during the period of litigation, there has to be some way of knowing who's going to live where, who's going to pay what bills. You've got your petition, service, response. Now you're in this temporary period. It's going to last for some period of time. And while you're in this temporary period, part of the divorce process, you're entitled to then start gathering information about your financial situation. And that can be done during this time period as part of the divorce process, either informally, where you and your husband just say, here's our bank records, and here's our tax records, and here's our pension, and here's our retirement accounts, and here's how much the car is worth, and go through all of the assets like we've done on the spreadsheet session, and then talk about what you think is best for the kids during this temporary period of time. And you guys can just informally agree on how you're going to set things up for this time period, and informally exchange information about your finances or your assets. So, but if you're not able to sit down as a friendly, across the table and figure this out, then you might have to use some of legal procedures. And so we're talking about the divorce process now, and one way of gathering information is called written interrogatories. An interrogatory is kind of like interrogation, sort of the same word. And what that means is you send a batch, it could be a lot, of written questions to your spouse and or his lawyer, depending if he has a lawyer or not, and he's required to answer all these questions under penalty of perjury, which means he has to tell the truth, allegedly, and obviously some people aren't completely truthful, But it'll say list every bank account you have and list your safe deposit boxes and where are your life insurance policies and how much money do you make and where do you have a pension and do you have any money deposited in anybody else's accounts, and goes through all these lengthy financial questions, asks for copies of credit card receipts and or billing statements, bank statements, retirement statements, stock portfolio statements, whatever there is that's financial in your world, he would be required to produce pursuant to your questions under oath from the interrogatories. So if you send those to him, the high likelihood is that he or his lawyer is going to send those to you, and then you're going to have to spend a whole bunch of time answering a lot of really lengthy questions, but it's a good and important way for you to gather information about your financial situation. So what you don't want to do is, it's not uncommon for me to be representing a woman who doesn't have very much information about the finances, and we send interrogatories and the husband says, oh, your lawyer's just doing that to make money, and I'll tell you what we've got, and we shouldn't have to go through this process. And that may be true and it may not be true, but this protection you have with interrogatories is it's signed under oath and penalty of perjury. So you're putting your opposing party in a position of having to come forward and represent to you and ultimately to the court what all he's got and where he's got money, and does he have any bank accounts that you don't know about, and what all real estate is there, and where are the mortgages being held, and what debt has he generated, are there credit cards you don't know about. So that all goes in the interrogatories. Another way that you can gather information, which is pretty common, is to send subpoenas. So let's say you're in a situation where you feel like, here's a common one. I've got a case right now where a woman doesn't have any financial information. Husband owns a company. And he says, oh, you know where our bank accounts are, and you know about our finances, and you know where our CPA is, and she kind of doesn't. So, we send interrogatories, but at the same time, we're also sending subpoenas. Rather than waiting for somebody to spend the time copying 6 months or 2 years or 5 years worth of financial records, sometimes it's easier and cheaper to just shoot a subpoena out and start gathering that information by subpoena. I can't just send a subpoena to you and say, produce your bank records. But if we're in a lawsuit together, then I've been given, as a lawyer, I have the subpoena power, which has got the backing of the court, to send something to a bank, and the bank has to then provide me with the records. Now, it gets a little bit confusing if you've got records that are out of state. So let's say that you live in Illinois, and your husband has some kind of an investment portfolio in Texas, and they don't have an office in Illinois. There are technical legal ways that you can go about getting a subpoena from Illinois to be honored in Texas, and it's not a simple process, but it's certainly doable. And that's one of those issue spotting things we're talking about. It means you have to say to the lawyer, we've got something out of state, we're going to need to get information about it, and then it'll be up to the lawyer to figure out how to get an appropriate subpoena to get that information.